3 Christian conservatives, Rich Penkoski from Warriors for Christ, Chris Severe of de facto Attorney General, and Tex Christopher of Special Forces of Liberty, filed a lawsuit in the Federal District Court in the District of Columbia against Mayor Bowser for displaying the Black Lives Matter banner on 16th Street near the White House, and for changing a nearby street name to Black Lives Matter Plaza. The lawsuit was brought pursuant to the Establishment Clause of the First Amendment of the United States Constitution. The plaintiffs are arguing that Black Lives Matter is a religious cult that the government cannot excessively entangle itself with. The plaintiffs base their case around what's called the Lemon Test. The Lemon Test is a three-pronged test created by the Supreme Court to determine whether or not government action fails the Establishment Clause. If government action fails one prong of lemon, it must be prohibited and enjoined. The plaintiffs argue that the mayor's decision to take taxpayer dollars to paint the massive Black Lives Matter banner on 16th Street and to change the street name fail all three prongs of the Lemon Test and therefore violate the First Amendment of the United States Constitution. Because 1, the policy decision lacks a primary secular purpose and is a sham that puts religion over non-religion. 2, the policy decision cultivates an indefensible legal weapon against non-observers of the religion of wokeness. And 3, the policy decision serves to excessively entangle the government with the religion of secular humanism, as advocated by the cult of Black Lives Matter. To demonstrate that Black Lives Matter is a religious cult, the plaintiffs point to the What We Believe section, which is viewable at blacklivesmatter.com. The Black Lives Matter organization fits the legal definition of a religion because it is organized, full, and provides its members with a private moral code by which they can lead their daily lives by. Black Lives Matter is routinely engaging in incantations and public ritualistic atonement ceremonies, which at times can include kneeling and washing of feet. The plaintiffs argue that Black Lives Matter's core doctrine amounts to a series of unproven faith-based assumptions and naked assertions that are implicitly religious and inseparably linked to the religion of secular humanism, also referred to as the religion of wokeness by political commentators like Ben Shapiro and Michael Knowles of the Daily Wire. The plaintiffs base their case on an enormous amount of existing legal authority. The Supreme Court has already held that secular humanism is a religion for the purpose of the First Amendment Establishment Clause in Torcaso versus Watkins. Just about all the federal court of appeals have found the same thing. This means that government actors like the mayor cannot take direct or symbolic action to erect permanent religious displays at the taxpayer's expense. The plaintiffs argue that the challenge displays convey to them and others that secular humanism, as advocated by Black Lives Matter, is the favored religion of the District of Columbia and of the nation. It reduces non-observers of that controversial religion that the plaintiffs believe is deeply immoral to second-class citizens and has a profound chilling effect on free speech. Not to mention that the ideology advocated by the Black Lives Matter cult is in large part an attempt to justify practices that are inconsistent with the peace and safety of the state, which means it has limited protections to begin with from a free speech perspective. The plaintiffs are seeking an immediate, temporary, and permanent injunction to have the Black Lives Matter banner on 16th Street removed and to have the Black Lives Matter Plaza street name changed to something secular at the city's expense. The plaintiffs are giving the court the discretion to order the mayor to replace the non-secular Black Lives Matter banner on 16th Street with a secular one at the city's expense, like Blue Lives Matter or All Lives Matter or Each Life Matters, only to be on display for the same amount of time that the non-secular Black Lives Matter banner was on display for. The bottom line is that the mayor of D.C. has violated her Article 6 duty to uphold the Constitution of the United States and offended the First Amendment Establishment Clause of the United States Constitution. Her conduct has been disrespectful to law enforcement and service discrediting towards the Army National Guard. And unless the federal judiciary starts allowing plaintiffs like the ones in this case to hold Democrats accountable for their failures to know the objective difference between right and wrong, real and fake, secular and non-secular, the country will continue to spiral into turmoil and toxic division.